courthouse. How are you? Good to see you. No change. I like it. You want to speak in seconds? You can't get another chair. Alan, you sit up here. Thank you so much. Appreciate it. It's a beautiful courthouse. Thank you. Yeah. He's good. A third chair is coming forthwith up. That's my contribution for the day. Appreciate it. If you want to sit right back here, you got some questions.
Which side are you doing?
Chair on this side, please.
I'm going to take that one. So it's just Anderson or? Yeah, he wants to be people for reception.
Who's that?
He wants to put that over here.
There's three more or something on one side.
Oh,
Are there any?
I gotta ask first.
Sure, yeah.
And if he says okay, then I can.
Yeah, no problem.
Okay.
Thank you, I appreciate it. So they go. The ones that went to the cinema, so they have pictures on two. That's right. The sixth is the new district.
It is.
Where's that?
It's, the headquarters is at Lakeland, the major population centers in Orlando.
Oh, I see. There was no district court one before, there are two now.
This was a district court that covered Orlando.
That's surprising.
It was, when they decided they needed a new district court of appeal, the Speaker of the House of Representatives was from Orlando. And that's what.
Oh, sure. That's fine.
There's Al there.
Yeah. perspective versus in the middle, because you get it.
What, but they set up, I was talking about the middle of all these pictures.
Oh, in the middle of the picture.
The folks that I actually sat with who were not even alive any longer, and passed on, and the ones that, the young ones.
Where's
But boys,
Is that here? Right there?
they set up, they have camping in the village.
Oh, right.
So, RVs and everything like that.
They do that in the animals. I understand also rules of civilized society. So, okay. That's all. He's going for a break there. And then, his eldest son is able to stay to study. I think it's a similar psychology. So they're running around, making arrangements for their break. I do too. First one's like, that was my just taking care of the son and all these other things. And he's also awesome fees. And right now, they're involved with Walkers and Walkers. It's a litigation over, it's basically a partnership dispute about cash calls. There's a new owner came in 3 years ago, and issued whose family has a mortgage company and whatnot. And so, he's very busy with that, and I try to stay up here for that. It's like being a mafia. You think you have each year, they're having failed. So. It's kind of not even very much of a love. Hi, I'm sorry. Nice to meet you. Hey, Kai, how are you?
How are you?
It's nice to see
Good to
you.
see you again. Yes,
You
sir.
recommended some of the finest barbecue I've ever had in my life.
Oh, good.
So, I'm Russ
Hi.
Myers. Nice to meet you.
Yeah, I'm the county attorney.
Good to see you again. You're looking
Been a long time.
It has been a long time.
Yeah.
Probably 4, 5, 6
I'm
years.
more of the guy with our county attorney.
Yeah.
Swing about. Jason, good to see you.
I'm Bill with me.
Yeah, yeah, we're just observers, you
Oh,
know.
I bet you. Everything good with you?
Yeah, you know, just,
You were ageless. All ageless. Practice for 34 years.
my dear's our county administrator.
Oh, is he?
He and I were talking about.
Right, right. I just heard it's all about himself.
You're a mere youth, you know.
I'm near youth,
Yeah.
and my wife is 4 years younger.
Oh, okay.
It's been made clear to me.
Right.
I will not be going on vacation
Yeah,
first. You know?
right, yeah.
So.
No, I'm kind, my wife is 5.5 years younger.
Oh, same thing.
Same kind of deal. So,
Yeah.
you guys have come to closure line. Yeah,
Well, it's so nice to
Okay,
see
yeah.
you, yeah.
Yeah, best
Yes.
wishes to you.
Thank you for everything.
She is not. Yes, go say hi. Well, I think she, I haven't seen her this morning. So. But yeah, just want to say hi. You were really well.
Okay. Okay. Well, yeah, I'm gonna leave you in the audience.
I'll be behind you guys.
I saw you taking pictures, and I'm always aware of that, in federal courtrooms, you're not allowed to.
Right. I asked, I was worried about it.
Did you ask?
I'm not from Florida, so I'm like,
Do we have permission?
yes.
Okay, good. In that case, I'm gonna do it too.
3 years ago. All it takes is the little one. Oh, because we landed in Jackson, there were 7 or 8 German planes lined up there. Oh, geez. If it was flooded, we say, oh, whatever. He just kept coming straight at us, we crossed the threshold and the guy parked up. This is what
J., Chief Judge presiding. All persons having interest in the down here, give attention and you will be heard. The United States of America, the state of Florida, the sovereign Lord. Please be seated.
Good morning. Welcome to the 5th District Court of Appeal. We are left with one oral argument today, which we will start with shortly. Thank you for being here. Thank you for being on time. Thank you for being receptive to our questions, because as the very fine advocates on both sides realize, that's why we're here, is to ask questions and to get some feedback from you about a case that we just learned about recently that you've lived with for a long time, which we understand, and that makes this a very profitable exercise. A few other mechanics, electronic devices, anything that may go off, alarm during this process, if you would be kind enough to turn those off, silence those, that would be appreciated. And let me briefly introduce my esteemed panel. I, as you may know, as you just heard, I'm Harvey J. I am very fortunate to be here with Judge Eisnagel, a longtime 5th District judge who preceded me here on this court, and also with Judge John McIver, and I've been fortunate to get to know Judge McIver, being in the Jacksonville area with him, and we actually started at the same time in January of 2023 on this court. Anything further before we get started? Who is planning to advocate on behalf of the appellants? All right, and so you may come to the podium. The first and only case today for us is ACAZ Ocala Ranch and Marion Mitigation versus Marion County. That is case number 2024-1709. Counsel, would you like to reserve any time for rebuttal?
I'd like to reserve 5 minutes for rebuttal.
I also, not that we want to incentivize this, but I want you to be aware, because we only have one oral argument. If the questions get spirited and it takes a little bit more time, we've got that time this morning. So we will certainly afford that, because I know we have big, important issues, as we always do, as to this case. When you're ready, you may proceed.
Thank you, Your Honor. May it please the Court, Matthew Gutierrez on behalf of the appellate landowners, AZ Ocala Ranch and Marion Mitigation. Your Honors, this appeal is about a county that defied its own local constitution, or what we call comprehensive plan, which established a policy called the Rural Community Policy to spur mixed-use development in the rural area of the county. The Rural Community Policy mandated that the county, quote, shall approve compliant applications for a rural community. The appellant landowners in this case submitted what was undisputedly a fully compliant application to build a rural community. In fact, at the board meeting, Commissioner Zalek, who is the chair of the Marion County Board of Commissioners, admitted, quote, the project is consistent with our comp plan. It is also undisputed that the landowners spent several years, in this case 3, and more than $2 million working directly with the county to ensure that the application—
Counsel, on the Burt Harris claim, what is the, so as I read your initial brief, which narrows the issues, right, that something has to be raised in the brief for us to reverse based upon that. Do you agree?
Sorry?
Do you agree that an argument has to be raised in the initial brief if we're going to reverse?
Yes, Your Honor.
On that? Okay.
Yes.
So anything not raised in the brief is waived, correct?
Yes.
Okay. As I read your initial brief, you rely not on the vested, as far as the Burt Harris claim, you rely not on the vested right, but rather on existing use.
Correct.
Okay. And within existing use, you don't argue that the plan, that the proposal was the actual present use. You go under the second sort of definition, right, that the activity or such reasonably foreseeable non-speculative land use.
Correct.
Right? That's your sole argument on Burt Harris.
Yes.
On this part. On this provision, so that's 70.001 3B2. What you do not address is the second half of that provision. And so I'm going to ask you what this language means. So you address the activity or such reasonably foreseeable non-speculative land uses which are suitable for the subject real property, compatible with adjacent land uses. And that's kind of where we stop in the brief. That's also where Oceans Concrete seems to stop. I'm not sure. I recall Oceans Concrete going beyond that. But the statute goes beyond that. And then the statute says, and which have created an existing fair market value in the property greater than the fair market value of the actual present use or activity. What does that language, that second part of this provision, what does that mean?
That's why we have the appraisal, Your Honor. It has to, if the use were actually allowed and it was not inordinately burdened and restricted, it would have created a present market value greater than what the current use of the property allowed. So in this case, we had an appraisal that said we lost $20 million because of the inordinate burden.
How is that? Well, you're talking about the inordinate burden provision now. That's not what I'm talking about. The inordinate burden provision in the statute is a totally separate provision. I'm asking about the existing use provision, which includes this language that says that the reasonably foreseeable non-speculative activity must have created, quote, created an existing fair market value in the property greater than the fair market value of the actual present use. So why does this not mean that basically this because a non-speculative use, if it's non-speculative, it makes sense that that would increase the fair market value of the property, even though it's not being used that way, correct?
Correct.
So how is this different than the inordinate burden calculation, and what does it mean for our case?
I don't think it is different. To the extent that something is a non-speculative use, obviously doesn't currently exist, but it is a non-speculative use.
Hold on. So, number one, it's your argument that the two provisions are superfluous? They mean the same thing?
Superfluous. I think to a certain extent they do overlap, but I don't think they're superfluous.
Okay, well, how are they not superfluous, counsel? If they mean the same thing, do they mean the same thing or not?
Yes.
Okay, so they're superfluous. One of the provisions is unnecessary.
I wouldn't say it's unnecessary, but they are the same thing. I mean, to the extent a non-speculative use.
Let me ask you this. If before the rural community, let's go into a theoretical world. So we're in a world before the rural community is built. Now let's look at the comparison, right? The rural community is now built. Let's say two different scenarios. Let's say that in the first world, the rural community, the potential for a rural community is non-speculative, right? And let's say it's non-speculative, let's assume that. And would the fair market value of the property probably go up some if that is a non-speculative potential use?
Yes.
Okay. Build the rural community. It's now a reality. Which has a higher fair market value, counsel?
I think when you're trying to assess what is the non-speculative increase in value before it's built, you're trying to figure out what the actual value would be if it were built.
Isn't that the inordinate burden?
They are two inquiries that are essentially, in our view, the same. We did address that. We talked about the $20 million appraisal. It's the lost value for the county's denial.
That's the inordinate burden, correct? And I understand what you're saying is they're the exact same thing. I think you have a statutory canon problem because generally speaking, we don't consider language superfluous in the statutes, generally speaking.
But in our case, Your Honor, we don't need one or the other, and the county's not raised this argument. This is not something that the
county's the appellee.
Right,
You're the appellant. They have no burden here.
But they also have not raised the argument because we think that it's sort of pretty straightforward in the statute. You do have two similar inquiries, but they both turn on the same thing. That doesn't mean one renders the other superfluous.
Well, I'm just not sure they do because this provision says the reasonably foreseeable non-speculative use creates an existing. That's what the statute says. Existing. I'm not writing this. This is what the statute says. Existing fair market value that is greater.
Correct.
Not a future if the project is completed.
But it
Before
says,
the project is completed, as I read this, the existing fair market value
because,
is higher just because of this non-speculative potential use.
right, and the non-speculative potential use attempts to figure out what would the property be worth with the use.
What does the word existing mean?
Existing in the present tense, in the present state of
statute
actuality.
here.
Excuse me?
In 70.001 3B2, what is the created an existing fair market value greater than?
In the
It says the existing. To me, that indicates before the rural community is built, the property already has an increase in its fair market value because the market knows, hey, we could do big things with this maybe, right?
right, and we
So,
have,
so those two market values are different.
I
One is
disagree.
the market value before the community is built. The other is what it would have been worth, right?
I disagree
After
because
approval, at least.
I disagree because the non-speculative use is a forward-looking assessment, and the forward-looking what you're trying to paint a picture of is what it would be worth when it's built. And of course, when it's built, you have a better, more concrete idea because you might have an actual bidder. But the exercise in the appraisal is attempting to figure out what that same value would be.
Is the 20 million? That's the inordinate burden, right? But is that the 20? That's 20 million. This property would have been worth 20 million when?
More
20 million more, right?
on the completion of the project.
Upon completion of the project. Why isn't 3B2 talking about the increased value before the project is approved or completed?
Because it's attempting to figure out what the value would be upon the completion of the project. They're sort of the same thing.
But it says existing.
So,
Well, if I could, it just says existing though. What does existing mean?
It means in the present state of actuality. That's what the word existing means, and it means what is the value of this land in terms of a non-speculative foreseeable use, and that depends on what the use would be. The non-speculative use, you're trying to figure out what is that? It's a rural community. Once it's built, how would that add the value? What change in value would occur to this land?
Sorry, Judge McIver, go ahead.
so, and maybe I'm just beating a dead horse or stating what's obvious to everybody, but it works easier for me if I can simplify this down a little bit. Have a piece of property on the beach. It's worth $10 million because I can put a hotel on it. Right now, it's worth $10 million. That's what I could sell it for today. Put the hotel on it, it's going to be worth $100 million. The existing value is the $10 million I can sell it for today, not the $100 million when the project is completed. It's the $10 million it's worth for today, which goes away if the county passes an ordinance that says you can't put a hotel on the beach. Is that the correct analysis of what the statute says?
No, I mean, we went the extra step. We actually have better information because not only do we have a property that undisputedly qualified, it was actually, the rural community policy was designed as they concede for this exact type of property in this exact area, but we went a step further. We worked for 2 years to develop plans for a rural community that was actually on the precipice of being built. So we don't have simply a project that was potentially going to one day authorize this. It's as if you sold to the market with the plans already in place, which is a more specific assessment of value. In our case, we actually had plans that were ready to go. At the 11th hour, the county changed them. So it's
So they weren't yet approved though, correct?
They were denied at the 11th hour, but after 2 years and millions of dollars working with the county officials to ensure a fully compliant rural community application.
I guess I'm going to go back to Judge McIver's example because I think that's a good one. I'm just going to add a wrinkle, and it would help if we could get a straight answer to this. So that it's the property's worth, in this hypothetical, the property's worth $10 million because it's not speculative that we could build a hotel there, right? Let's just assume it's not speculative. Once we build the hotel, the property's worth $100 million. But if suddenly you couldn't build a hotel at all, now it's only worth 2. See what I mean?
Yes.
So, right now in this moment, you have the county commission says, no, you can't build a hotel. There's no hotel there. They say, hey, we're going to go ahead and build a hotel. The county commission says, no, you can't build a hotel. That property then, the value of that property doesn't go from 100 million to 2. It goes from 10 to 2, right?
I disagree.
Oh, okay.
Because we have actually taken steps, not only just the existence of the property on the beach, but say you market it for sale, you would market it with the plans, with the investment of $2 million, with the fully ready to go.
It's not worth 100 million, right? You agree with that?
That's up to the
And
appraiser.
it hasn't been approved yet. It's not worth 100 million. In this hypothetical, you
So
have,
this sort of begs the question because our position is that it was required to be approved under the county's governing
let's
comprehensive
say for a
plan.
moment we disagree that it was a foregone conclusion that it had to be approved. Let's say we've looked at the policies language and we don't think that it was an automatic. So take that out of the picture. Now go back to our 2 million, 10 million, 100 million. Do you see the difference between, hey, we think there's a non-speculative use here, that increases the value of the property from 2 to 10, right? But the moment you get it approved and build it, right? Even more value then. So why is B2 not talking when it says existing fair market value? Why is it not talking about the 10 million stage and not the 100 million stage?
It's sort of an undisputed issue in this case. We submit that at the moment that the reasonably foreseeable use was taken away from us, it was not simply the existence of the property in an area that may have qualified for this. We were further along in our
Oh,
process.
no, this is the definition of existing use. You
Correct.
have to establish this in order to establish you had an existing use.
We don't disagree with that. We are simply saying it was not just that the property was in this area, in this particular property, and the owners of it had gone through a 3-year process and spent millions of dollars, increasing the value of their non-speculative foreseeable use. So if you were to
So they're increasing it from 2 to 10 million.
correct.
Okay.
Well, I'm sorry, no. From in your hypothetical, from up to 100 million is what under your hypothetical,
Mm-hmm.
the appraisal was the goal of the appraisal was to figure out what would be the value if these plans, which
So
we
what I'm-
submit we were
I'm
entitled
not
to
asking
build.
about that phase. I'm asking about the $10 million phase, right? That this property, if there's a non-speculative use, that's going to increase the market value differently than once the project's completed. I think we've agreed on that, right? Like there's a value, the statute seems to say there's a value to that. The fact that this property could be used to build a hotel, even though it's not approved and it hasn't been built. The fact that it could be used as a hotel is probably going to increase the market value by some amount, right? So I guess that's what I'm saying is what does this mean? Is that what this means? Is that what does it say, hey, in order to establish an existing use, you have to show that the market value of the property has increased based upon that non-speculative use, above and beyond the existing use.
I guess what I would say is I don't see the disconnect. Respectfully, we believe that the two numbers are the same. We have an appraisal that was based on plans that we submit, we were entitled to build, and I think that would resolve this dispute.
I want to ask a little bit about that entitlement aspect. So I don't think you go so far as to argue that the final county commission hearing was ministerial, that they needed a rubber stamp. They certainly were allowed to consider and approve or deny the application. You're arguing that it's couched by the parameters of the comprehensive plan policies, yes?
Our position is that once we submitted a fully compliant rural community application with zoning and land use components that satisfied every criteria in the rural community policy, that we were entitled to the approval of that. The language in the policy says that a compliant application, quote, shall be approved.
So then am I mistaken? You are saying that the county commission hearing was ministerial?
It's not ministerial. They had to assure that we complied with all of the requirements, which are technical in nature. And to the extent we didn't satisfy the requirements, then they could have denied it. But it is undisputed in this particular case that we satisfied every aspect of the policy.
To what extent does the public testimony come into play there? So what public testimony could have been made at the county commission hearing that would have been appropriate to support a denial?
Well, what I can say is that the public testimony about whether or not this type of development and this type of property in this area of the county, whether or not that was a good or bad idea, was not something that was fair game at that hearing. Because
that's probably an answer to my next question, but my question was, what could they appropriately have brought? That what would have been fair game? I mean, if the county commission meeting had any meaning as a governing body meeting at all, what were they supposed to be considering as comment from the public?
To the extent that somebody disagreed that there was 40% green space, or that the density was in excess of what was permitted by the policy, those types of things would have been fair game. But based on the wording of the comprehensive plan and the word shall, which is mandatory, what was not permitted was a reconsideration of the policy that was already memorialized in the county's governing constitution, which was a comprehensive plan. So, Your Honors, I will save what little time I have left for rebuttal if there are no further questions.
Give you more time.
Thank you, Your Honors.
And so I will give you a minute 21 to deal with what you were just asked, and then an additional 5 minutes for
Thank you, Your Honor.
rebuttal, which means the other side will have 6.5 minutes if you're so inclined. You don't have to use it, but please, if you want to say anything else before you sit down, if not, you'll have 6:21 for rebuttal.
Sure. I'll conclude my opening remarks with this. The county disputes that this is a mandatory policy, but what they cite to are general observations made by courts about the relationship between land use designations and zoning. They say things like land use provides the ceiling, zoning does not have to always match the ceiling. But I'm really glad that they cited to the Boca Raton case, because I think that answers the question before this court, the critical question, whether or not we were entitled to this once we satisfied the criteria. In the Boca Raton case, the court was dealing with a comprehensive plan that didn't use the word shall, it used the word may, and that was actually the dispositive word that the court focused on when it talked about, well, if you have a land use designation that authorizes a maximum use, zoning may match the maximum use, but it need not. It's only permissible. The entire focus of that argument or that conclusion was the word may, and they cited the permissive mandatory canon out of the Scalia-Garner canon. They said, because it's the word may, it's permissible. In our case, we have the word shall, and therefore our position is that once we satisfied the rural community policy,
Council,
we were entitled.
Which shall are you referring to? Are you referring to the shall be approved with a PUD zoning classification?
Yes.
Okay. So isn't that after the rural community is already approved and it's become a rural community on Flume?
The policy doesn't say that. There's no conditional language. It's not restricted in any way based on the.
Well, without it being a rural community, then the zoning issue, that's the second step, right? Isn't that the second step? First you have to approve it as a rural community.
The statute authorizes the applications to be submitted and considered concurrently. So
okay, but they're separate, right?
They are two separate applications. But
so if the Flume is denied, then you wouldn't even get to the zoning issue.
But that sort of brings us back to the original question: is were we entitled to a change of the Flume? Were we entitled to the rural community policy?
But I guess that's my point: is it shouldn't that be the initial focus? Because if you lose on that, you lose.
Well,
yes or no? You lose on Flume, you lose.
But I disagree that they're separate in this particular case because we are entitled to a change of the Flume. Therefore, and the county has to be consistent.
I understand, but that doesn't change the fact that if you lose on Flume, and I understand, but if we disagree with you and you lose on Flume, then the zoning issue is irrelevant, correct? We don't even get there.
If you disagree with our interpretation of the of the requirement, the obligation of the county to approve this, then of course we lose. But it's our view that the two in this case are one and the same. They collapse in on one another. The question is whether.
But the shall you're referring to is at record 1142.
Yes.
Shall be approved with the PUD zoning classification.
Yes.
Okay.
So if there are no further questions, Your Honors, I'll reserve, however much time you will give me for rebuttal. Thank you.
It'll be 3.5 minutes for rebuttal.
May it please the court, my name is Christina Lehm, appearing on behalf of Marion County, the appellee. With respect to the Bert Harris issue, the appellants are asking this court for making an extraordinary request of this court to have Marion County essentially cover the lost profit of their project because their applications were denied.
I don't understand how the grandfather provision applies.
Okay, let's discuss that. So the grandfather provision applies because the ordinance that was applied to the property is the 1994 ordinance that applies the land use designation to the property.
Well, wait, hold on, Counselor. You said the ordinance that applied to the property is the 95 ordinance, but what do you do with 11A2 that says the law or regulation is first applied to the property when there is a formal denial? Isn't there a compelling argument that the denial here was based on the 2014 comprehensive plan / rural community policy?
Yes, so and to answer your question, but with a brief preface, the purpose behind the act is to provide relief.
The purpose you're telling me other than the words, ma'am. Respectfully, and I mean that with the greatest respect. I'm just looking at words. You use the word applied, and I see applied in 11A2. What do you do with that?
So that's because the whole preface of the act is that it's a new ordinance that restricts and burdens the property. Here, this new policy that they're seeking is not one that's been applied to the property and burdened and restricted the use. This is not a situation where...
I don't see that in the text. I appreciate your words. They're good words, but I just don't see that in the text.
If you look at the case we have cited, the Casca versus City of Coral Gables...
I read it last night. That's not our case. Respectfully, Judge Logue's opinion. And as I read that case, it was predicated upon a 1984 ordinance reg that, by all accounts, was dispositive. That's not this case. So, separate apart from the third DCA case, where in the text of 11A2 do you find what you just said?
The applied to... The way I read it is in the context of the new ordinance that's the purpose of the act is founded on the fact that there is some sort of new ordinance that burdens the property, and that's what is applied. That's
not actually what the act says. I mean, we can say that's the purpose. Mm-hmm. Maybe that's what legislators thought when they passed it. Maybe they didn't, but that's not the law. The law is what's written in the statute. And why isn't this grandfather clause? I mean, this grandfather clause seems to me when I read it, it is specifically addressing a new rule, a new ordinance, right? That's not the issue here. The issue here is a denial of the rural community, right? So and like, look, we can look elsewhere in the act, in the statute, but. Look, I don't think that this is certainly not a situation that is the classic Bert Harris claim.
Right.
But that doesn't matter. If it meets the language of the statute, it doesn't matter if it's that's not a defense, that's not the classic situation. And other parts of the statute seem to indicate that this could be, I'm not saying it is, but it could be a legitimate cognizable claim under Bert Harris. This grandfather provision seems to be directed to if you pass a new regulation, right, then that's different than enforcing an old regulation.
But the entire act is directed to a new law, an ordinance.
Well, if I could analogize to admin law, I think the argument the other side is making could be analogized to you taking action or an agency that would take action based upon an unadopted rule. They're suggesting that you have de facto repealed the RC by not applying it, and that would be an unadopted rule change under admin law. Here, what they're saying is that you de facto repealed that without actually going through the process of repeal, applied that to their case to deny them. And that would be applying a new regulation, the unadopted repeal, to their situation. Tell me why that analysis might be wrong.
Because it's not a de facto appeal. This application went through the entire statutory process and was considered and reviewed. And
Did you deny them based upon the RC policy, or did you deny them based upon other things in their argument because you found that the RC policy was no longer sound?
No, it was not denied based on the RC policy no longer being sound. And no, they argue that. But it went through the entire statutory process and was found to not be compatible with the adjacent land use or in the public interest after the entire process was completed.
Council, I want to go back to the grandfather clause in a second, but on this point, in their briefing, they focus on arguments that were made in court, as opposed to arguments and discussion that was at that took place at the county commission meeting.
Yeah.
Okay. Do you agree with that?
I think this is a review, obviously, of the trial court's decision, so we can look at both.
No, I'm saying the motivations, whatever the motivations were for the denial.
Right.
The briefing on the other side focuses on what the lawyers argued after the fact.
Right.
More so than what the county commissioners said.
Yes.
Do you agree with that? Do you agree that is the focus of the briefing on
yes.
the other side? Okay.
Yeah.
Do you, if we only look at the county commission meeting, at the legislative body,
Yes.
Which I'm not sure lawyers can change what a legislative body intends to do or what their motives are, but if we only look at the county commission and their what motivated them and what they said, did they make this decision based upon just not liking the policy?
No, of course not, Your Honor. Then that's what I meant. They went through the entire statutory process and reviewed the application. They heard public comments. I mean, this is an elected body who obviously is interested in listening.
I mean, there were experts on both sides of this, right? Weren't there some experts saying, hey, it would be reasonable to deny this because of traffic and infrastructure issues and things like that?
So with respect to that comp plan amendment, there was a tremendous amount of evidence presented even at the public hearing in the form of the county staff, but also in the form of the neighboring locals. I mean, 22 people showed up to oppose this, and this wasn't just we don't like the project or we don't like AZ Ocala. That wasn't it. It was lived experiences and factual details. There were, and in addition,
like water issues,
yes,
right?
I mean, when people show up and say, I can't run 2 faucets in my house at the same time, that's how little water I have. And then you have one of the 13 retained out-of-state consultants saying, don't worry, 6,000 units and 2 golf courses are not going to make a difference on the water level. I mean, I think that's fairly debatable.
Council, going back to the grandfather clause, I think part of your problem on this is that the statute specifically recognizes a cause of action for, quote, specific action of a government entity. Action of a government entity is defined as specific action of a government entity which affects real property, including acting on an application or a permit. It doesn't just include adopting or enforcing an ordinance. You agree? Would this be acting on an application?
A denial would, yeah.
I'd be acting on it, right?
Yeah.
Okay.
But to just finish off the Beto Harris situation here, it does contemplate an actual loss. So that's not what we have here. This is a hoped-for, expected outcome, as if the board's function was just ministerial, as if they expected the board to rubber stamp their application. And to move past the grandfather clause into their argument concerning existing use, I mean, there's just not an existing fair market value that's created in this property based on the policy just being available. I understand it's their argument that they were automatically entitled, and that has evolved over time. Because
What does this language mean in 3B2, the second part of 3B2?
so an existing fair market value in the property greater than the fair market value of the actual present use or activity on the real property.
The non-speculative land use has quote, created an existing fair market value.
Right. So for instance, in Ocean Concrete, which they rely on, there was a situation where the you have the land without any use on it, but the zoning specifically provided that you could have a concrete batch plant on the property if you wanted to. It was enumerated and protected in the statute. Now, that's a reasonable expected use that could create some additional value in the present value of the property, even if you didn't have the concrete batch plant. And then a later ordinance.
Just because some buyer says, hey, man, we could buy that and put a
Absolutely.
concrete plant on it.
Yeah, but you don't have that here, because that policy, the RC land use policy, is contingent on the board's approval, and that is a fundamental policy-making function.
Are you
No one
arguing
can
that
be
that
entitled-
approval is a plenary legislative function?
Say it again,
Are
sorry.
you arguing that that is a plenary legislative function?
That is, a fundamental legislative function
Then
to,
why do we have a Growth Management Act at all? Are you not cabined by the Growth Management Act to follow your comprehensive plan, to be consistent with the comprehensive plan? Are the things that the board has to consider during that final hearing, do they not have to be things that are guided by that policy?
absolutely, Your Honor, and that's what they did. The board here did.
Then it wouldn't be plenary. It's an application of policy to the application. It is not a legislative decision.
Make sure that we are distinguishing that the zoning is an application of policy, whereas the amendment to the future land use map and to the comp plan is a legislative function. So that's why no one can be entitled to an outcome of a legislative function, because they're planning for the future land use of the entire county, not just this property. And even though the other side keeps saying that we conceded that their property was ideal for this, that's simply not correct. It's entirely possible that this land use policy would be an excellent option for a property that was, let's say, right outside the urban growth boundary, where it would have the infrastructure that it was needed, like the hospitals, the fire station, etc. Whereas this, in a remote part of the county, it doesn't have proper access roads. There is only a voluntary fire station. It doesn't have any hospitals or emergency medical services. And this is a senior community. This is 6,000 units of a senior community that doesn't have any fire station nearby. It doesn't have any emergency medical services. That's why this particular property is not suited for this particular policy. It's no animosity towards the appellants. It's not personal to them. It's just that this may be a good policy on a different property, but just not on this one.
What do you say to the argument that the shall language, I think it was on 1142 of the record, shall, let me try to find it again, referring to the rezoning.
Yeah, that just talks about the corresponding zoning that would be approved. That does not take the comp plan amendment out of the game, because essentially, under appellant's interpretation, they want this court to completely disregard Chapter 163's comprehensive plan amendment structure. They want to disregard the need for a public hearing and all the other.
If the flume step was appropriate and occurred,
yeah,
then would the rezoning be mandatory at that point because of the word shall?
I don't think that is the intent behind the word shall. I think there's still discretion, but I think
it's at least It's at least a close question, right? Because shall generally,
yeah,
right?
It's a closer question, but
I would
they
submit
don't
that shall
get to that
always
stage.
means mandatory, but right. If you meant may, you'd say may. But I guess my point is that the shall referencing the zoning issue. Do you agree that we don't get there if the flume wasn't approved.
Exactly. I mean, it's entirely contingent on a comprehensive
Is there any
plan.
language saying that the flume must be approved, shall be approved?
No, there's not. And that, because that's the whole function of the structure that's laid out in the comp plan amendment, because the flume is part of the comp plan, and it can only be amended through that statutory process. And appellants want you to disregard that entire statutory process based on the word shall here. And that's just not the law. In addition, they say that, well, the zoning application could be submitted concurrently. That is correct. But in the statute, it expressly says that the application of or the zoning application is only contingent on the approval.
I mean, just because they can be submitted at the same time doesn't mean that that one isn't dependent on the other, right?
Right, and it says
Okay.
so in the statute, that the zoning is contingent on the land use being approved. So you never reach, in my opinion, you never reach the zoning question.
On the Burt Harris claim, going back to that, again, I recognize it's not the classic example of a Burt Harris claim, but based on my review, it really does seem like this 3B2, this language in 3B2 is pretty important for our purposes here, what this language means. That's the language of creating an existing fair market value greater than the fair market value of the actual present use. Just how is that language, how is the meaning of this language in 3B2 different than the inordinate burden calculation, if at all?
I think the court illustrated that with the example before, that the $100 million is the 7.0012E1, and the $10 million is the existing fair market value. But going back to the example where, for instance, there was the Ocean Concrete case where there was an opportunity to build something on the property that was already provided for in the zoning, it's not the situation here. Here, the fair market value is whatever the fair market value is, regardless of what policy is out there in the comp plan that may be applied for. All the policy says is that it may be requested. It is not a foregone conclusion. So the appellants treat this function, the entire statutory scheme, as like a rubber stamp. We submitted a technically compliant application. Ergo, it should be granted. No, a technically compliant application just gets you in the door. That's the bare minimum. Otherwise, why would you even get to a final hearing if you haven't complied with the technicalities? There is absolutely no language in the statute or in the case law that makes approval of a comp plan amendment just a perfunctory function if you happen to show up with a technically compliant application.
I want to ask you about the argument that existing use was not pled. The reply brief, if I recall correctly, pointed to one part of the operative complaint that I'm not sure actually pled it. In fact, I think it didn't. But it does seem that the issue was litigated heavily by both sides in summary judgment. So what's the effect of that, right? Not that an appellee has a burden on appeal, not in Florida, but there are sort of concepts, right, that if both sides just litigate it and
that was my concern. Now, this was resolved in summary judgment. It didn't go through a full trial, obviously. But generally, a plaintiff can't recover an unpled claim. And it wasn't pled here.
Unless it's tried by consent, though. And I know it's not tried here because we're in summary judgment, but I'm just not sure why, I don't know. Why isn't...
There was no evidentiary hearing on this. There was no trial on this. It was resolved on summary judgment. So I do still think it has merit that it wasn't a pled claim.
Okay.
So, but regardless of the grandfather clause, we don't believe that they showed an existing use. It's only on the basis that they think that the board should just rubber stamp their application. That's the only way that they will have an existing use, and that's just not not reasonable and certainly not foreseeable.
Can I ask you a question on 163, chapter 163?
Yes.
So it's 163, 3215. 3, relating to the de novo action of it for any aggrieved or adversely affected party. And it refers to granting or denying an application for a development order. That seems to match our situation.
Right.
But then if we read the statute carefully, it says, on the basis that the development order materially alters the use or density or intensity of use on the property, rendering it not consistent with the comprehensive plan. That language doesn't seem to quite, it's questionable whether that lines up with our situation, because I'm not sure the development order in this case could be said to alter the use or density or intensity of use
That's correct.
on the property.
That's correct, Your Honor, and that is the basis. It literally says in the cause of action here that's available here is that cause of action has to be on the basis of such not just an altering decision, but it materially.
In other words, it doesn't mean that there's not a cause of action, right, in this situation. I mean, there could be Bert Harris, there could be other things going on, but on the consistency argument,
yes,
the statute seems to suggest that the development order has to actually alter the use, as opposed to not alter the use.
It's clearly in the statute, and it would have to be disregarded if it could just be the potential denial of a potential use. That would not alter the entitlements on the property. They stayed the same since 1994.
But again, that brings us back to our first argument about what does existing use mean, and it includes reasonably foreseeable, non-speculative.
Under the Bert Harris Act. But in the context of the consistency challenge,
Yeah.
the cause of action is based on materially alters use, density, or intensity. Those are the three bases. And this court reiterated that in the Lake Rosa versus Board of County Commissioners case, where it specifically...
But I think Judge McIver's point is that even if we read this 163 consistent with what you're saying here, if we read it that way, that still doesn't get you off the hook on Bert Harris, right?
I think those are probably two different inquiries.
Yeah.
In terms of what existing use is there, but it's the consistency challenge is certainly limited to reviewing the use, density, and intensity. So with respect to the comp plan amendment, I just want to make sure that we covered everything there in terms of it being fairly debatable. The board, even going back to what the board covered, the Board of Commissioners did its job. It considered the infrastructure, the environmental impact, and the financial impact on the county. The public was greatly concerned. 22 people showed up and explained their lived experience. They were also greatly concerned about the environmental impact, and the county was...
I'm curious about one thing. If you had 22 people show up at the final hearing, and all of their testimony was this impact, we don't like this impact, and they described an impact that was specifically approved in the comp plan policy, would that be an appropriate basis for denial? Could you just phrase that amorphously as public interest and then deny?
I think that when you think about the fact that it might be in the comp plan, but it still has to be applied on a property-by-property basis. So one...
Right, but the comp plan specifically has a policy that says we allow for X. Everybody comes in and says, we don't like this amendment because it's going to provide X. Well, that's specifically provided in the comp plan.
Understood.
If they did that and you said, well, this is outside the public interest because we had 22 people come in and say they didn't like it, would that be appropriate?
No, I don't think that the opinions in that sense would necessarily negate what's in the comp plan, obviously. But there's no such situation here in the comp plan because the environmental impact is not covered in the comp plan as just an automatic approval. There are a few requirements in the comp plan with respect to this type of policy, and really the only requirement is that the tract has to be 300 acres. That's essentially the only initial requirement. But this comes back to my example where I said, well, if you had a property of 300 acres that was immediately on the outside of the urban growth boundary, well, then the RC policy may be compatible with the adjacent land use and in the public interest, because you would have the infrastructure, hospitals, fire station, proper access roads. You may have less environmental impact because it wasn't in a preservation area. So while that rural community policy may be available for some properties, it just wasn't, or appropriate for some properties, it just wasn't appropriate for this, as voiced by the locals who showed up in great numbers. And it has to be taken into consideration where this property is located. So I want to bring one citation to the court's attention.
Counsel, I'm not sure. I definitely could not cite you to the record here. I could be wrong about this. And so I'll ask you, and then your opposing counsel has at least some time, and we can grant more time if necessary to answer questions. But did the opposing side admit below that the rural community policy is not self-executing?
Absolutely, Your Honor. And let's not forget.
At some point, they essentially conceded that, right?
Yes, in their response to the motion for summary judgment on that.
But that's it seems like they're not conceding that now, though.
Well, this has been an evolving theory, because at the very beginning, their initial attorney, Mr. Gray, contacted the county, and if we start back there, they were completely aware that they needed a land use amendment, and that there was no thought that it was self-effectuating or obligated to grant it. Instead, in the letter from August 2015, Mr. Gray contacts the county and says, we're considering this project. We know that it's a large-scale project, and we need a comp plan amendment to assign the rural community policy to our property, and a rezoning application as well. And we intend to file both. And that's exactly what they did. I mean, they wouldn't have filed a comp plan amendment application if they didn't need to. They went through the entire 2-year process under that assumption. They went through half the litigation with that understanding, the way the claims were ordered, etc. It wasn't until the third amended complaint that they switched the order of the counts to say, well, we're pleading the comp amendment, the alternative now. Instead, we just need a zoning because it's self-effectuating. Then during litigation, they receded from that and admitted it's not self-effectuating. In the initial brief, it wasn't quite clear what they were
Hold on, let me
arguing.
just clarify here. Right, I understand initially the self-executing issue wasn't part of it. It seems fair enough that at some point they said, hey, wait a minute, this is self-executing. Like, I'm not saying I agree with it, I'm just saying that seems fair that at some point they would think that that's an argument, right? And it seems fair that they could present it at that point because the case wasn't over, correct? But I just want to be clear. So then they make the argument, they take the position that it's self-executing.
Yes.
After that, my recollection is after that, at some point they conceded that in fact it isn't self-executing.
Correct.
Is that correct?
Correct.
Okay.
Yes, and it's in the briefs. I believe it was the response to a motion for summary judgment, but it's quoted in the brief. And then in the appeal, it is unclear in the initial brief if they're still perpetuating the self-effectuating policy without using the word. They clarified in their reply that in fact what they meant was that the county was obligated. Now the word obligated in any variety, in any form, does not appear once in the initial brief. So this has been an evolving theory over time. But it was never presented in the trial court. It certainly was never presented to the board during the application process.
Well, it was maybe presented but then withdrawn.
That's what I thought. I thought it was the same thing, that what they meant was self-effectuating. But in the reply, they're crystal clear, no, we're not saying it's self-effectuating. We're instead saying the board was obligated to grant the application. But that was never argued in the trial court.
Okay.
I see my time is up. So if there are no further questions, we ask that the court affirm the judgment.
Thank you.
Thank you.
Thank you, Your Honor. So my colleague on the other side started by saying that we're making an extraordinary request. We're asking the court, according to them, to interfere with the legislative prerogative of a board of county commissioners sitting in their legislative capacity. And of course, courts are not in the business of second-guessing legislative policy decisions. We're not asking for that. We're asking for something more fundamental. Enforce the governing constitution that curbed the discretion of the county when sitting in their legislative capacity.
Council, assume for a moment that we interpret B3B2 in the Burt Harris claim, the definition of existing use. Assume for a moment, just as a hypothetical, that we disagree with your interpretation of that and that we think it's something different than the inordinate burden analysis. Did you present evidence below of that the non-speculative use created an existing fair market value greater than the fair market value of the actual present use on the property?
Aside from the appraisal, I'm not aware of such evidence.
Okay.
What was that evidence? What went into the appraisal, just so we know?
The appraisal valued what the appraiser thought was the value, the increase in the value if the rural community property would have been approved. And he came to the conclusion that it was at least $20 million more valuable with the rural community policy.
Was there any evidence, bootstrapping off Judge McIver's question below, anywhere, that there was this enhanced value by virtue of the potential for being able to have a community like this, as opposed to an actual built community? Was there any evidence of that?
I'm not aware of such evidence, Your Honor. The second point my colleague raised is that the board did not repeal this because it was bad policy. And there is a distinction between what was discussed at the hearing and what was discussed in litigation. But when you're talking about defending what occurred at the board meeting, your litigation position is what you are interpreting as the party what occurred at the board hearing. I don't think that there's much daylight between saying if people are complaining about the water levels, for example, at the hearing, I think that is subsumed within the county's comprehensive plan's judgment that this is a good policy for this exact type of area. They've conceded that as written, the rural community designation was not restricted to any particular part of the rural area. It was written without any such restriction. So I do think that the county's litigation position describing the rationale why the county rejected the application is in direct contravention of the policy rationale that was memorialized in the comprehensive plan and that governed their discretion at the hearing.
Point to anything at the actual county commission hearing that would support that position.
Yes.
Setting aside the things that lawyers said in the litigation, what is it?
The commissioners talked about the importance of infill, and now infill is better. So maximizing development within the urban area. That is directly at odds with the policy goal of spurring development outside the urban area. And that's I forget which commissioner said that, but the focus on that comment was we want infill. I'll touch on the consistency issue in terms of whether or not the development order must alter the use density or intensity. This brings us back to square one. Are we entitled to a rural community once we submit a fully compliant application? If we are, then the denial of the change of the use density or intensity.
Fair enough. If it's self-executing or something along those lines, then it would arguably alter. Is your point, right?
That's the point, but we don't need it to be self-executing. And the way I understand the county uses the word self-executing, and that the way I think we initially used it below in the trial court at the initial stages, as you observed, is that it was sort of an automatic thing. We're not saying it was automatic. We still had to go through the process because we had to prove compliance with the rural community policy. They're saying that there were additional steps. It's on a case-by-case, property-by-property basis. That could usually be the case, but they decided to draft a rural community policy that didn't say that. Their policy said shall be approved, And the court, in interpreting plain text without limitation, the word shall is mandatory. So in our view,
Of course, we have to figure out what, because that's connected to the PUD zoning issue, right? So we have to figure that
So-
part out. In other words, it's not quite as clear as what you're presenting here.
I disagree. It's not quite as clear. The word shall, so it's actually more, they're saying there is no language that requires a change to the flume map. We have something better. The policy doesn't say that. That's true. It says something better. It says the development shall be authorized through the planned unit development designation in the zoning code. So that entails an amendment to the flume map. That this goes the extra step. You must approve the development itself. That's what the actual policy says, which requires a flume map amendment in the normal course. And in terms of saying, with respect to the Burt-Harris Act, it's the same thing as the consistency challenge question. They're saying it was the 1994 ordinance that was applied, not the 2014 rural community policy, because it preserved the entitlements of 1994. Again, goes back to square one. Were we entitled to a change of those entitlements? And if we were, then the policy that was misapplied, was the 2014 rural community policy. So with all that being said, Your Honors, we ask the court to enforce Florida law, protect the private property rights of these Florida landowners, and reverse the entry of summary judgment and remand for trial. Thank you.
Thank you both. It was well presented on both sides. If there's nothing else, we'll be in recess.